He's like to withhold that for a little while.
And
Dylan Parkerson.
Dylan, Parkerson judge, I'd like to have a reset on that. There's some additional investigation.
How much time do you need? 4 weeks?
4 weeks.
That's all? Okay. That's reset. Darius Smith. Who goes to trial for unlawful possession of a firearm by a felon?
I'm not trying to go to trial. I just know Mr. Rose is a busy man, and I was just trying to get the case resolved.
Oh, you were,
Well,
he says he,
because
I'm not offering probation.
schools and all parts.
what's he offering? What's he offering?
The offer on it is, 4 years, 4 years TDC.
Hold on, but I'm sorry, y'all are going a little fast. So is Mr. Palmer going over there?
Yeah.
Okay. And then Mr. Parkerson being reset.
Right.
Okay, thank you. Sorry.
Yes, I just.
It's not highlighted. That's fine.
Zane, you're still testing positive. You're not getting out to that changes. So you're taking it into custody.
Say is he's lying with the fucking get back.
Again, Darius Smith. Yeah, this conviction on June 7th out of Ellis County. So every time, so you commit a third-degree felony each time you're unlawfully possessing a firearm.
Oh, that probably, hold on. Let me share the logs.
Yes, please.
Yeah.
What other
and-
convictions do you have?
I have a felony marijuana.
The one in 17 from Ellis County, right?
Yes, sir.
What else? That's it.
Mr. Newman, please raise your right hand and swear to affirm and the truth and the truth and the truth shall be God. Need you to each of your right and right. Okay, please sit down.
There's a firearm underneath your seat, the driver's seat.
Yes, sir.
And what's your defense on this?
I had forgot it was there that morning.
That ain't, that's so what?
I understand, but I had took it for like.
It's that extended mag style where he's got 30 rounds, Judge.
See, you're not eligible for probation. You're not eligible even in front of a jury for a conviction. Prior felony conviction. I don't know if you understand that or not, so.
2.5 right now in school. I was just.
So what?
in school.
Yeah, you got like, just like me.
Yeah.
What would I lose
Yeah.
if I commit a crime? A lot more than you. That's why
Yes, sir.
I don't commit crimes, but,
I understand.
um,
So I had got there from my home.
it doesn't matter.
I know.
It's illegal possession. I mean, it's, it's,
They was trying to keep.
the lowest is 2. They can do 2. Yes. How much time does he have credit?
Judge, he thinks he has only a week over the show. Probably not much.
2 days.
Hmm?
2 days.
Yeah.
Yeah. 24 CR 1771 is called the State of Texas versus Terrence Newman. That is you, sir?
Yes, sir. Good morning.
With your attorney and the state's attorney. Does, Mr. Gamma, does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about August 4th, 2020, I'm sorry. Yeah, August 4th, 2024 in Jefferson County, Texas, you committed a third-degree felony of assault, family violence by intentionally, knowingly, or recklessly impeding the breathing or circulation of the victim by applying pressure to the victim's neck, choking. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. In your case, where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. It will be shortened if you do well to a third, which is 3 1/3. No fine. There will be terms and conditions of probation, which are normal and customary for this type of offense. Do you understand?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked here as State's Exhibit 1. Did you sign that document? Voluntarily? Did you understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection.
No objection.
Admitted. Among other things, the state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and only lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record, and I make findings supporting what the court has just related on the record and the responses affirmatively by the defendant. And I find all of that in State's Exhibit 1 to be true and correct. If nothing further.
Dustin, were you going to ask about the term of probation?
Not necessarily, Judge. We put down an agreement for 5 years, but we understand the court can set the length.
And if it's, I shorten it every day, 3 1/3. But what do y'all want?
We agreed to 5.
What do you want?
I'm okay with 5, Judge.
If nothing further, I'm going to find there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, but I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions here, sir, that are normal and customary. There's something that we always use in this type of case called batterer's intervention protection program. It's a good thing. It helps people reflect when they lose their composure. I think everybody loses composure from time to time, and this puts it into your mind to relax, think, and foresee what kind of problems you can get yourself into if you don't act responsibly and you let your passion get the best of you, which happens to all of us from time to time. So please see the probation officer and you will begin probation. Thank you. Anything else? That is sound.
No, Judge, I do have Rodney Broussard.
Yeah.
It's going to be,
All right, we call 2 matters, 23 CR 1813 and 23 CR 2223, the state of Texas versus Rodney Allen Broussard. That's you?
There should be a third, Your Honor.
A third one.
MTRP. It should be 2512 and 40.
24 CR 220. There are 3 first amended motions to revoke unadjudicated probation. The defendant is on probation for evading arrest or detention with a motor vehicle in each of these cases, right? 3rd-degree felony. The first, well, these are failures to report. But look, there was a motion to revoke probation filed on February 20th, which alleged those first 3 grounds of failing to report August, September, and October 2024, failing to provide verification of community service hours, failing to pay court assessed fees. And then later on, the first amended gets filed on March 27th of 25, like 5 weeks later. And it alleges failing to report to the probation office, which is already in the first one, December of 2024, which is a new month, January and February. So we have allegations that he failed August, September, October. Nothing in November.
He was in jail.
He was in jail. Then was he released from jail? And then December, January, February. Okay, while we're looking that up. What's the deal?
The agreement is for him to go to Sec P. And
What's the deal? Why is he not reporting? Because the one thing you have to do is report. I don't care. I mean, I do care. You can fail to do everything else with good reasons, but if you fail to report unless you're physically unable, then you're not on supervision. And I open the door for one, I open the door for everybody. If there aren't consequences that are severe, you got to report. You got to show up. If you don't show up, you're marked absent and you're gone. And probation is a waste of everybody's time if you're not going to appear. We can't be searching for how many, 5,000 people? Roughly 5,000 people. Whatever's good for you, if they can go. I want the Rodney Broussard rule. I'm going to not report for a while, and then if y'all catch me, then I'll be able to get out of jail free. You don't have 166 days. 5 months. So what was the deal? I mean, he had the first one, then he's in custody, then he gets out and he just doesn't do it again?
Exactly.
Well, how many chances do you get?
August, I actually got picked up that day that I was going to my probation.
Yeah.
Warrant in
Whatever.
No, really.
Everybody says that. The point is you weren't there.
Yes, that,
but he had a warrant out in Louisiana and he was arrested. He was in jail.
yeah, it was literally some fortunate circumstances. And when I got out, sorry.
Okay. Well, if you're in custody, you can't report. I mean, it would be a defense. But when were you not in custody? When were you free and didn't report? That's what I
I got
want.
out very end of December. Like
So
2 days
August,
before Christmas.
September, and October of 24, you're in custody?
Yes, sir.
Is that right? Well, why would we file that if he's in custody? He can't report if he's in custody.
I believe he was in custody August and September.
No, I wasn't, man. Got picked up August 14th.
Well, she'll know.
If he was in custody somewhere else, Judge, I'm not gonna have that information.
Where were you in custody in August?
Louisiana. He had a Louisiana warrant.
He was in custody here.
And they picked me up here August 14th before the Louisiana warrant.
And then you went to Louisiana in December, was there for a couple of days. They let you out.
I was there for about a week and a half. Then I got out right a few days before Christmas. And then the holidays and then January. So pretty much I was like January from everywhere else. And then I missed January and February. And then they immediately picked me up on the warrant for that. Everything whenever I got out, they have a place to stay or anything, it's not the right thing or anything. I have to use of transportation due to situations I put myself in. Because of the unfortunate thing that kind of it's not really have a place to stay or really count on. I put myself in to report to make those calls or to make sure that I was able to go to push it. It was failures on my end, but also through some very stagnant circumstances. That's where if there's a good environment, that's really.
It was in September when I talked to your brother. He was bringing you up in the program. And that was September 13th. So you weren't in custody.
To be off by 1 month.
Yeah.
Okay, what's the answer? What months did he fail to report?
January and February 2025. For certain.
And he got out in July. He got put on probation in July 24.
Yes, ma'am.
And he did not report in August and September.
I know, but if they're in custody,
Yeah.
they can't do that. And that's the question is, it seems, I know what he's saying, what we're saying, but it's not
August,
matching. I want to know what the truth is. And that's why I want to know what is accurate.
it's possible he was in custody in August. It's possible he did report in August. We don't have that exact date, but he was released in December. The amended.
How often was he supposed to report?
And well, he went to his initial intake in Beaumont, then he never reported to me. So I've never actually seen him in the office, but he should be reporting at least every month or 2 months. When he
But
got
they're
out.
ordered to like once a week, once a month.
Mhm. But I never saw him to get an assessment to see where he was gonna
Oh,
be
he absconded from it.
before he ever saw me in office.
Explain that.
Well, like I said a minute ago, he was picked up.
No, he hadn't been picked up for half a year. He's been available to report.
Since the.
How many times since you were released in July, how many times have you been to our probation office?
One time,
One time?
yes,
One time?
For initial intake.
yeah.
One time
End of July.
in July.
End of July, enrolled into the probation.
And, okay. It's May.
But then in August, I was picked up and I'd gone to jail.
So you've been on probation for 9 months and you only reported at the beginning?
The very first report after he got put on probation.
9 months you've been
It's
in
not-
custody?
The judge,
No, I want to know that. You lie to me and you're gone.
No, Your Honor.
Go ahead. Try to trick me. You're gone. I got 3 cases here. And you're looking at what, 10 years on each one? Go ahead. Try to fool me. You tell me in 9 months that you hadn't been able to find your way to the probation office?
he was in custody for 5.
I want to know if he was in custody for 9 months. If he was, if that's fine. But if he wasn't, shame on him, because that's what I'm being led to.
That's the dates that he was in Jefferson County.
In Jefferson County, it was September 18th to 12/24. So that's a little less than 3 months. Then he's in Jefferson County, 3/25 to 5/25, May,
That's to today.
today. So then we've got from 12/12, well, he was released in August, you said? Or July?
He was put on probation at the end of July.
Okay, so we have something in August we don't know about. He never reported in August at all. Then he gets put in our jail on September 18th. He's released on 12/12.
To go to Louisiana, but he was only stayed about a week and a half in Louisiana.
Okay.
So he failed to report January, February.
All right.
In August.
August, January, February. Okay, 3 months. That fair?
It's fair.
But you can't do anything else. You got to report, or you're AWOL. You ever been to the military? When you go AWOL, they arrest you and you're in the brig. They don't put you on the front lines. You're in the brig. But you got 3 cases here. And what was going on in Louisiana?
It's the same case.
It's not the same case. It had to be a different case, sir.
Evading
What happened in Jefferson County, Louisiana doesn't have any responsibility over, we do. What happened?
What he's saying, Judge, is that he evaded police in
The
Texas.
same thing?
Into Louisiana and evaded those police in Louisiana. Same day.
Do we have a problem learning a lesson?
Yes.
Okay, so it says What's the status of the case in Louisiana,
Doesn't care.
Mr. Galmore? What's the status of
I don't
Louisiana?
have a judgment or anything from Louisiana. What was the outcome?
Yeah, I went there and took it part and put me on probation. I'm on probation. It started in January.
Okay, I think I know. So what are we doing then? Now, what do we want to do? I'm not talking about you. I'm talking about this, the state and the defense.
I want to let him go to safety and see if he can be better this time. He was only on probation really for a couple of months. He got out of jail. He didn't report. He should have definitely reported. But I'm hoping that if we send him to safety, he can continue all three of these probations and his Louisiana probation. And if he doesn't, we'll revoke him and we'll sentence him to prison.
That's pretty. Okay. All right. What we're about to do is what's going to be called the Rodney Broussard rule from now on. You get to do this and you get a chance to go to safety. Is that what we want to open the door? What's good for him is good for everybody. Is that the message we want to send? You can scamper out for a few months and we're here to help you. Do it. No, we've got to force you to do the right thing. I'm reluctant to open that door for everybody because that's what I'm going to do. But I'll do it. Everybody gets this then. All right, on these first amended motions, the state, you failed to report in allegation 4 in each of these cases. Is that true or untrue? Are you pleading true to that voluntarily and because it is true? You understand a plea of true?
Yes.
And knowing plea of true is enough to grant a motion to revoke probation. The probation can be revoked. You can then be found guilty and sentenced up to the full range of punishment. Knowing that, do you insist on pleading true today in each of these allegations?
Yeah.
Right. In each case, 1813, 2223, and 2222. Okay. Even though there's enough evidence to revoke, I'm going to continue you on probation. And there will be terms and conditions of probation, which will include an additional term of entering and successfully completing the substance abuse felony punishment facility cases. Sign those. Those are all the 3 cases. You will be continued on probation, and we'll see where that goes.
Thank you, Judge.
Yeah, intentionally flee from Jonathan Cabrera, a person the defendant knew was a peace officer.
Okay, lady. Okay, yes. So,
That's a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable for this type of offense?
yes,
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which you would not be found guilty. And that would be for 5 years and a fine $500. There would be other terms and conditions of probation. If you satisfied the terms, then at the end, the probation is dismissed. If you failed, your probation could be revoked. You could be found guilty and then sentenced up to 10 years in prison. So it's got a lot riding on doing the right thing and following the rules. If I follow this agreement, you have no right of appeal. Do you understand?
yes,
How do you plead to this? Guilty or not guilty?
guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes,
I show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and
Yes.
correct? States Exhibit 1 tendered in
Okay.
evidence without objection admitted. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, brother. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true. It states so help you God.
Yes.
States Exhibit 1, part of the record for all purposes, and the court acknowledges those are findings of fact that the court is positively making in the record for this case. Pre-sentence report waived.
Yes, it is.
I'm going to follow this agreement, if nothing further, and place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions that the probation office is going to go over, will go over with you. Make sure you follow those. You're going to be fined $500, and this will pass quickly enough as long as you follow what is required of you. At the end, your probation would be dismissed and you would not be found guilty. You also are going to be required to take a defensive driving course. That's a win-win. It helps you make better choices. Plus your insurance will reduce. I mean, it's a win, yes, everybody. It's a good idea for everybody to take it after a period of time. Okay, please see the probation officer. Thank you. Versus, is it Kanisha?
Yes.
Kanisha, ma'am?
Shawnee.
Shanisha, sorry. Shanisha, Mims. You're here with Mr. Grove, your attorney, and the state's attorney.
Yes.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment, ma'am, handed up by the grand jury on February this year. It alleges that on or about August 24th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here?
Yes.
If convicted of a third-degree felony, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? What is the agreement? Anita, prosecutor, there you go.
It's 10 years to be probated and $1,000 fine.
Yes, sir.
Is it regular probation?
Yes, Your Honor.
Yes, sir. Regular probation.
There's an agreement that's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fine $1,000. Then there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand? Man, no, it's regular. We call regular probation. But you're on probation. You're found guilty and you're sentenced, but you're not, you don't go serve your sentence so long as you follow the terms and conditions of probation.
Yes.
Then at the end, if you do well, the case is terminated.
No.
But it's not dismissed, it's terminated.
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I show you what's marked as State's Exhibit 1, little things off. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence.
No objection, Your Honor.
Without objection, admitted. This thing, where does this darn thing fit anyway?
It fits sideways on the bottom. You've got the 2 little prongs here on the bottom, and you place it sideways on it.
Yeah.
Yeah.
It doesn't snap.
They don't hold very well.
Among other things, this stage you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this, it states, is true, so help you God. And the court makes findings supporting those statements that State's Exhibit 1 represents, and the court finds all of that to be true, and it is part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I am going to follow this agreement, ma'am, and find that there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended. You are placed on regular probation for 10 years. You must pay a fine of $1,000. There will be terms and conditions of probation, including you must successfully complete defensive driving and other conditions of probation, which are normal and customary for this type of offense. You do well at the end, your case can be terminated successfully. Okay. Please see the probation officer. Thank you very much.
You're on probation officer, this thing, not you. You go down the other court.
You are Darius Smith, present with Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 18th, 2024 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of a firearm by a previous convicted felon. Do you understand what you were charged with?
So,
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
yes, sir.
An agreement's been reached in your case where you will be pleading guilty. Whatever sentence shall not exceed a cap of 4 years in prison. We'll order a pre-sentence report and come back after that is done, and then everybody gets to sound in, and then the court makes its decision.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I think you're looking at no less than 2, no more than 4 years confinement. You're looking at deferred or unadjudicated probation, and also regular probation can be assessed. So those are 3 options. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this states so help you God. Is that a true and correct?
Yes, sir.
The State's Exhibit 1 is made a part of the record for all purposes. And the court makes findings in support of State's Exhibit 1. And those findings are in accordance with the recitations in State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report will be ordered. We'll be returning back, and you'll get a resetting. Everybody will come back and sound in, and then the court will make its decision then. And please get a resetting from this lady. What is it, about 4 weeks?
I did June 20th.
You're Ernesto Jesus Solana. Present, you have to speak out so this lady can.
Yes.
Okay. You are here with David Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that, just go around here and I'm going to talk to you while you're doing this fingerprint of operating a motor vehicle while you were intoxicated with a child passenger. Do you understand what you're charged with?
Yes.
It's a state jail felony, which means if you face confinement in a state jail for any term of not less than 180 days or more than 2 years Additionally, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for up to 5 years and fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, it is.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign this document voluntarily? Did you understand it, discuss it with your attorney? Or are the contents all true and correct?
Yes.
Yes, you have to speak out.
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
Admitted. I will find that here you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Correct?
Correct.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is now waived.
Yes, Your Honor.
I'm going to follow this agreement based upon the findings, and I find that the evidence supports from State's Exhibit 1 the indictment, and I hereby find you guilty beyond a reasonable doubt of this state jail felony of operating a motor vehicle while intoxicated with a child passenger. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That is suspended. You were placed on regular probation for 5 years. You must pay a fine of $500. You shall complete a DWI course as directed. There will be other terms and conditions of probation, which are normal and customary for this type of offense.
One more signature. I think I saw it.
Confinement on a DWI misdemeanor, you get what you're ordered, 10 days?
3
It's
days.
the third, DWI with a child passenger, there's not any upfront time that they have to do.
There's no upfront on misdemeanor?
Well, under that particular statute, there's not
Right.
For DWI.
for DWI.
What, on this case, what are we doing? What do we want? Anything recommended by the state?
Not for any upfront time, no.
Okay. Then make sure you do better. All right, see the probation officer. Thank
He
you.
learned his lesson. I think it's just the court wants them to resubmit the case and discuss it with me.
Is that right, sir?
Yes, sir.
Well, what's the offer? Do you know?
4 years to it.
It's 4 years TDC, Your Honor, and he has no prior conviction. for-
Is that-
Yeah,
Is- Who's on that?
He has a prior, he does have priors.
What do you have on it?
He has, it's possession of a firearm by a felon, so obviously he has a prior.
He has an assault on a security officer for which he did 2 years. That he was originally given deferred adjudication for, and he also is currently on federal supervision.
No,
For what?
Well, you were on federal supervision.
you say Kurt. But
For what?
A weapons charge?
What is the weapons from?
I don't remember exactly. I was on Pacer.
What court? What district? Eastern District, was Texas? Out of Baltimore.
To be unlawful transport of firearms.
What was the sentence on that?
36 months. With 18 months supervised release.
Yeah. He went to federal prison and then there was supervised release afterward.
Yes,
Yes. Total of 5 years.
like parole.
So what's the offer on this one?
4 years TDC.
When was that federal crime committee? When was he sentenced for that?
2020.
Okay, that's a prior conviction. That isn't alleged though,
No, it is not one
No,
of the,
sir.
but it could be. If they want, if they allege it, then it moves it up to a second degree felony, if they could add that, yeah. What do y'all, is that what you want? Looking at up to 20 years? I don't think so. So what's the offer on this?
The offer was 4 years TDC, I believe.
yes.
All right. And in front of a jury, you're not eligible for probation, so you can't get probation in front of a jury. What are we gonna do on this?
Can I go to trial? Can we take it to trial?
Yeah, I'm gonna give them time to re-indict it and add that prior conviction. And yeah, you can go to trial. You're not eligible for trial, but you're looking at 20 years, up to 20 years. That's your business. We'll do it. That's what we'll do. That's what we'll do. And
I believe, Judge, that's what he wanted to do.
all right, then it's set for trial.
Originally.
But it's gonna they're gonna have a chance to re-indict it and add the prior felony.
So the prior
Federal.
felony, the federal, it counts to.
Yes, all felonies, federal or state count, yeah. It doesn't matter, it says a prior conviction, which means in any state or the United States district courts. Then I was in the United States Attorney's office for 20 years, and I know how that works. It's never forgotten. It's not in the past. It's always hovering. And I'll give the state a chance to re-indict, but we'll set it for trial, and that's what we'll do. And we'll let a jury decide, I guess, if that's what y'all want, okay? And there's no deals. When it comes back, we're gonna move it fast. We're gonna set it for trial quickly so we can figure out where his life is gonna go. And that's it on that. Corlina Solomon,
Oh, yes.
Corlina Solomon.
Judge, Carlina Solomon is here. I believe that Mr. Owens wanted to talk to the court about another attorney.
You don't have a right to pick an attorney. David Grove is a fine attorney. You don't get a choice. You can hire somebody.
Yeah,
Yeah, go ahead. Go ahead and hire somebody. I'm going to set it for trial. He's going to be with your attorney and advise you until you can get somebody else. Okay.
Okay.
All right. Get it resetting. We're going to put it on the fast track. I want this. We can try this one. That's it. Those are fast trials to try, and we can move that. Carlina Solomon.
Yes, sir. She's been here all morning.
Yeah. What are we doing on Miss Solomon?
Judge, I think we just kind of got lost in the shuffle, so to speak.
Who's on this one? State? What are we gonna do? What state want to do?
I think we had previously offered, I think we offered 7 years on it.
I believe that's correct. 7 years TDC.
She have a prior conviction or something?
Yes, sir.
So she's not eligible for parole.
Well, the indictment does not have a
I know, but it doesn't matter. It doesn't have to be if it's proven at trial. It just needs, she needs is notice of it. Is there prior conviction that y'all are gonna use? Or not? No? Do you have any convictions? No.
Those two aggravated.
Just this
You do
charge?
have- You do have 2 aggravated assault charge convictions. That was what the judge had. Yes, sir, she does.
Where are they? Out of Jefferson County? Can you pull those up, please? You don't have, what are y'all showing? Showing.
Those are the two active cases, and then she has a civil case. That's all I'm saying.
This not showing.
I don't see any priors.
Do you have a prior? Oh, I thought you said you had 2. I thought that's what y'all were saying.
Two aggravated assault charges.
Oh,
She has an assault in it.
You're talking about charges that are pending, not felony
I
convictions.
misunderstood what she said.
Okay, y'all gotta be straight with me. Come on.
Yes, sir.
The problem is, a deadly weapon, you can't get probation for a deadly weapon in front of a jury. So you go to court, if you're found guilty, you're gonna go to prison because of the deadly weapon. That's why you gotta think long and hard about trying to, what's the off on this? Did you say
7 years, Your Honor, TDC. Alleged to have stabbed an individual in the arm with a knife.
Or the kitchen knife. Judge, could we reset this case for a couple of weeks so I have some more time to talk to Mr.
2 weeks.
Tallman, also.
Reset 2 weeks.
Okay.
Reset 2 weeks. Thank you. What about, get a resetting, please, ma'am?